Welcome back, friends. It is our pleasure, to have you again on this platform, wherein we try to discuss a lot of things, lot of issues, lot of new innovations, ideas, etc. Today, we are fortunate again to have with us Dr. Abhik Bhattacharya from IIT Roorkee. As you are already known him for last two episodes, we have been following on electric vehicles, and we have followed on product development life cycle, etc., etc. So in that episode, if you have not watched that, obviously I will be putting those into the description link. You can go and watch it because these are very important and interesting sort of ideas and discussions that has been taken place, which talks more about the EV ecosystem as well as the opportunities that are there in the EV industry, both as an entrepreneur or as well as any person who is more interested to join that sort of a league. Interestingly, in the previous episode, when we were discussing about the product development cycle, some interesting facts came up in which we promised that there will be a separate sort of a discussion and episode. So this is the day today, and today we are going to uh, discuss on the patenting affair. I mean, how do we patent? What is a patent? And what are the typical requirements, why one should be patenting, what are the different myths surrounding this topic, the intellectual property rights that we have, and how does it matter in the whole ecosystem, particularly with focus on EVs, electric vehicles, both the prototypes as well as the software and hardware ideations. So before we start, there's a simple request to all of you, my friends, is subscribe this channel and do like and share these videos and comment also, so that we are able to get your views, and in future we can also do a lot of improvements that are required. So Professor Dr. Abhik Bhattacharya, welcome back, sir. Nice to have you again on this platform, and it's really a pleasure to be in this sort of a podcast and series where we are learning every day, every episode. So today's topic, as you are aware, it's about patent filing, and I'll just open the discussion forum to you to take it forward, sir, as you wish. Over to you, sir.
Thank you. Thank you again for inviting me in your platform and share my experience and knowledge while filing a patent. And I am basically sharing a journey as a co-passengers. Okay, so I hope that my experience, what I have learned, that will help you to file a patent. Because we started discussion with a startup, then for EVs, the career opportunities in EV rather. Then we talked about the startup as a major focus area, and then we come to the product development cycle. And once we discuss the product development cycle, we discover that another important aspect we require to discuss is the
Patent.
patenting the idea. So for this reason, again, we have decided to do the again today. Maybe in our discussion terms, topic will be what
Mhm.
we will be doing on it. Okay, so anyway,
No,
so
there are other topics also lined up that we have
right,
discussed
right,
here.
right. Okay, right, agree. So what is a patent? In patent, we generally say that it is an intellectual property. Like we own a house, that is a property, and once we file a patent, it is just like a registering our property.
Mm.
So there is a process. Of course, you should have an idea or a product or innovation which can be patented. So that is actually something. What is patent? If we will say that it is an exclusive right granted by the granted by the authority, that is the government of India here, an invention that is new, and mostly it involves uh, the innovative steps, and and it is required to have a industrial applications. Fundamental research can't be patented. So for this reason, we require to understand it. We require to go for the applications. So what patent gives us, like once we register our apartment or house, then we get a legal rights, right?
Mm-hmm.
So we became the owner of that thought process, and that definitely doesn't allow other to simply copying or using for sell for other things. And so you are being protected by your ideas, and you can commercialize your idea, and by that way you can earn the revenue. That is one aspect of it. Another most important aspect, that is for the startup point of view, it is quite important. Generally, we require to raise a fund to run the business. So we may get the seed fund initially, that for incubations. Thereafter, we will be approached to the venture capitalist or any other investors to fund our startup. But at that time, your product may not come out.
Mm-hmm.
Then how you will value your company? That is a very big question. So we may discuss again this topic. How you will value a startup in the different stages of its development.
Yes, this is also very important, sir. This is
So
also very.
so ultimately you go to a one investors, whatever value they decided, you decide to take that only, and ultimately you, because you require the money, they
Mm-hmm.
find a lot of startup like you.
Right.
Then definitely the differentiator will be the uh, your patents. So definitely that if your company a similar startup, if you don't have a patent,
Mm-hmm.
definitely we cannot negotiate to dilute their equities, but you
Mm-hmm.
can, and you can actually, you can put your value at least 200 times more. Otherwise, you will have only the book value to assess it. So how can you defend your value?
Mm-hmm.
So
Very
patent definitely for the startup will defend the value.
right.
So for this reason, it is also very important, because ultimately we require to the cash flow to run the business. So thus patent is a very powerful tool as far as the startup point of view.
Mm-hmm.
And thus, it is a business tool again.
Mm-hmm.
And how many patents that company owns, based on that, they are being valued also.
Mm-hmm.
Now, in general, patent is granted for the 20 years in India.
Okay.
So, assuming that they are maintaining the patent, there is a license fees for the patent that is quite nominal, and it has a territorial rights. And definitely, if you file a patent, it is not that uh, we have a territorial limit. So only in India it is valid. So
Okay.
you require to file another patents in another country to get it protected from there. Like we do file sometime US patent, Japan's patent, etc. If we find that their company can take that product or idea. For example,
Okay.
I can share an important information I have written in my book. G. Marconi definitely owned the radio patent in Europe, but still, Sir Jesse was owned the radio patent in USA.
In USA, right.
So it is because of the fact that Swami Vivekananda actually initiated that process, and ultimately it was filed.
Mm-hmm.
So
Actually,
patent
it
is not
was.
a new concept. All
Yeah.
stalwart has done the patent.
Right. Right. In fact, he was so much of a philanthropist. He didn't want to have any patents because he wanted to have everything for the mankind. So you are free to use his innovations, ideas, inventions. So that is one of the reason why we have such a low reckoning because everything now is commercialized. Everything ideas are commercialized. Everything is
Right.
on the product concept. So if that is there, someone's name is stamped on that, because the ideation and everything comes from that patenting, which we call the intellectual property right. If that is given to everyone, so obviously the inventor loses his or her value, which has happened over past in our history.
Uh,
So maybe that is another reason why we should more be focusing on
right.
patenting our ideas, at least in India. Yes, sir, please.
Acha, I just summarize our these discussions.
Hmm. Hmm.
So, what are the objectives of the patent? So, if you 1, 2, 3, 4 in that way, definitely that preventing others from the patenting the same innovation or
Hmm.
invention. Or there is a difference between innovation and invention, anyway. So,
Right.
uh, and discourage unlawful copying. Definitely, you will get protected.
Hmm.
And third point, I told you that generating revenue through licensing. That IIT Roorkee Institute, like IIT Roorkee, we sell the patents to
Hmm.
the respective companies. Like I personally sold my uh, patent to a startup,
Hmm.
so that way we generate the revenue.
Hmm.
And then definitely in a because you might be knowing that there is a different kind of ranking of the
Hmm.
universities and academic institutions, QS ranking, Times ranking. They
Hmm.
do value patents quite
Hmm.
regularly, and they so academic institution if does patent, they have been accredited well above the other institutions,
Okay.
and
Okay.
definitely attracting investment and funding. That I told you that
Hmm.
startup definitely will have required the funding,
Hmm.
and we require to value our company once we don't have the product is been launched. Once
Right.
we have a uh, once we have a product launched, we have this turnover.
Hmm.
Assessing the company is easy,
Hmm.
but
Hmm.
once we
Hmm.
have not actually launched the product in that time actually, and we require to get a fund from an investors. So definitely, patent will help to get the fund, as well as you can raise the limit of your funding also.
Right. Right.
And then it help also the technology exchanges via cross licensing, because you might be knowing that the Ford and Toyota has swiped their patents.
Hmm.
Ford gave the electric vehicles patents, uh, and Toyota gives their actually the diesel engine patents, and so that is also possible. Like many companies swipes their patents, and that is also a collaborative business, but that is in a higher end, and definitely it will facilitate to entry to the new market if you have a patents. These are essentially, if I summarize, these are the objectives of the patent. And for the startup, I must say that it is almost a must to activity.
Right, sir. Right.
Now, the question arises that criteria for the patentability.
Hmm.
So, criteria for patentability, definitely I will jot down 3 points here again. The nobility. So, by brainstorming and all those idea, you find that the idea is noble, the product, or by simulation SIL, that is software in loops, any other way, you also validate your
Okay.
idea.
Okay.
So once you have validated the idea, definitely, if you have a nobility, then definitely you require to find non-obviousness. It means that if it is so trivial, so you
Hmm.
cannot patent, and also you require to find the industrial applications for the nobility.
Okay.
So there are like X-ray was
Hmm.
discovered by in 1895. Within couple of years, it was commercialized.
Right.
Whereas photon, was discovered in 1905 by
Hmm.
Einstein. Ultimately, laser came into the application much, much later.
Right.
So it depends. So we require to find it out its industrial applications. That is very
Mhm.
important.
So if there is a possibility of an industrial application, then only we can actually think of patenting. But otherwise, it will be more treated as a fundamental sort of a research. Is that the idea, sir?
No, problem lies, let's say radar.
Hmm.
Okay, radar. It can be but like you never know now whose idea will come.
Hmm.
Concept of the radar was stationary waves, etc. So that was quite long. But in Second World War, people realized that they required it.
Hmm. Hmm.
Ultimately, they go back to the scientists, and then scientists found the solutions.
Right.
Right. So,
Hmm.
and the reverse can be there. If you have if you find any novelty
Hmm.
of an existing system, definitely, if you can brainstorm, then definitely you will find its industrial application. It may be so that you know uh, that uh, cost effectiveness, etc., and that is the product development cycle. But once you are in a TRL level 1 and 2, that is, there is a term called TRL, technology transfer level. From the basic science, you get to the technology.
Hmm. Hmm.
So once you validate the idea, will scale down version, in
Hmm.
lab version,
Hmm.
then definitely, you will be convinced that it has got an industrial application, but it requires the scalability,
Correct. Right. Obviously, without scalability, the industrial application has no meaning. In fact.
right?
Hmm.
So for uh, then definitely you start working on a different TRL level.
Hmm. Hmm.
So you move to the TRL level gradually, ultimately come to the TRL level 7. That is the that is
Right.
the stage of the commercialization.
Okay. Right. Right.
Ideally, the product when in a TRL level 4 to 3 to 4,
Hmm.
you can think of to patent.
Acha.
Because if the product is already in 7,
Hmm.
you are too late. You are late entrant.
Acha. Okay. So that's we can term as the cyclic revolution of the product itself, in
Right.
which it has taken up.
So definitely, there is a product cycles now, so it will mature and all. Late
Right.
entrant definitely will not get the benefit.
So the
So
technology maturity is already achieved, so you cannot have
definitely.
any technology. Right.
So try to get patent once in a TRL level 3 or 4.
Hmm. Okay. So, like, suppose, sir, if a corollary in terms like what we are discussing, in terms like what DRDO does, is more to do with they develop the product or they develop the technology, and then they go for the technology transfer through. Now, what they are doing is through private participation, in which they transfer the technology, because the access of information and the sort of the ecosystem that is there in defense is certainly different from what we are talking in terms of electric vehicles and its ecosystem, because there is a lot of monopolization in terms of research that is there in defense, and not an every entrant is allowed. It is government controlled. So they are more now focusing on to develop technology, to develop IPRs in terms of different, sort of missiles, armaments, etc. etc.
Right. No. Let's. DRDO is a a defense
Hmm.
research organization.
Right.
The DRDO is not an ordnance company.
Correct.
So and the people are there are researchers.
Hmm.
So for this reason, they required to take that different TRL level and ultimately, develop the prototype and give to the best bidder
Correct.
to manufacture it.
Right, sir.
So because no point of and that and there is a scope of private participations, because
Mm.
if there is a monopoly, we see that that several time our air chief has raised that issue with the
Right.
HAL.
Mm, mm, mm.
So if it is a monopoly, then that those issue arises, and it gives the government to government, okay, chalta hai attitude.
Right.
So for this reason, for this it is very much important. It have the competitive bidding and etc. And the
Mm.
private player can come into the pictures, so that they can give so that actually this market flourishes. And of course you will have a limited production. Now definitely defense is a very big business. So
Right.
India was a net importer. Now gradually after Sindoor, I can see that India will double their export by next 10 years,
Yes. Yes.
because of that, because of the Akash air defense system, everyone want to buy.
Mm, mm.
So how can DRDO produce that much of the production? We require to collaborate with the private partners,
Right.
and there, of course, we require to we cannot stake uh, our national security. So that clause has to be governed by the government.
Right. Over here we are actually discussing something like on the IPRs are coming from private individuals or certain small companies who are the startups, and who has a noble idea which is has an industrial application, and that can be patented because patenting brings in lot of benefits that we discussed. So that's the
Patent
idea, and the way we
patent
are ahead.
essentially identifies your potential.
Correct. Right. The
Right.
idea's potential to some extent, sir.
You got an idea, then once you get patented, your potential has been realized.
Correct. Correct.
Then you convert into the earning. That is
Hmm.
your job also. That is also a very tough job.
Right. So that is the again the second chapter in which we are trying to bring in commercialization to the
Definitely.
ideas. Right.
Acha, by the way, we require to understand few terms before we discuss about how to file a patent.
Hmm.
And like institute like us, people like me and my students, or the scientist in DRDO, all those are essentially are the inventors, because
Okay.
we put our memories there,
Hmm.
our expertise there, and we will be inventors. And and generally, the organizations or the company is called entity,
Okay.
right?
Okay.
And most of the cases, that entity actually is the
Okay.
applicant, holder, and the owner of the patent.
Okay.
But in some circumstances, if you have a own patent, so you can be the inventor and you can be the entity.
Right. If it is my own
So
idea, my own sort of a research, so
right.
the entity
So
and the inventor will be same.
so that depends. So once you are filing a patent, if you don't have a company, then inventor can be the entity.
Hmm.
Otherwise, inventor will be the company, and individuals who contributed to the patent will be the inventor. There is a reason behind it. You can. That's why I said that once you say that I have a patent, so you can encash that patent to your own consumption, and you can actually pay yourself back
Hmm.
if it is your own company also.
Hmm. Hmm. You're right.
So there is a different way to do that. And in uh, so we can that is a different issue. Once we file a patent, we come to
Hmm.
know. And then the before actually finding the patent, uh, first thing, we definitely, what I said, that you do the very brainstorm very thoroughly and come out with the idea. So once you get into the idea, then try to search the database.
Okay.
Okay, so and another problem I personally face, that you have to search database in many languages, especially Mandarin, Chinese language,
Okay.
okay, South Korean language.
Mm-hmm.
So patent can be on their language also,
Okay.
because that patent is published in Mandarin, only the title matches, maybe title is
Mm.
given in English, but whole papers and its claim are can be Mandarin.
Okay.
So in that way, you have to be very meticulous. And we have one. IIT Roorkee has one database, that is a pet database. So we have a pet service also. If you
Mm-hmm.
approach our incubation cell and you write for the access to this database, we get shown some token money and we allow them to access. Because I suggest, please do the paid database subscriptions and be thorough with that,
Mm-hmm.
because it increases the confidence, reliability in
Mm-hmm.
mobility checking. Okay.
Mm-hmm.
So
Right.
for our case, like for our IPR office is involved,
Mm-hmm.
and uh, they give us free
Mm.
anyway. But they have purchased a database,
Mm.
and independent inventor can directly approach to the India Patent Office,
Mm.
and they can search from the database also, and they also charge some amount of money based on my knowledge, because I did it to the IPR office of the IIT Roorkee. So this scope was not, this is not required for me, but Indian Patent Office, one can go and search the database. Database searching is very important, and it has to be very meticulous. If you have a two three inventors, you search multiple time,
Mm. Mm.
and then and please note that every country has its own patent office.
Mm.
For example, IPO in India, US PTO in USA, JPO in Japan. Huh?
Mm-hmm.
So they have its own jurisdictions, and some paid database allowed you to actually go through those patent. Okay, go to those patent offices database and to search for it. So you know then whether this patent may be available in India, but it is already patented is in USA.
Mm.
So that is something that you must know.
Okay. But if it is patented in USA and we are only patenting in India, that is allowed or no?
It is uh, it is allowed.
Hmm.
And that's what I say, that filing in one country does not protect the invention in other
Other.
countries.
Hmm. Hmm.
So if someone has patented the US patent, so you can file an Indian patent.
Correct.
So in general, it doesn't happen, because there is such a non-linearity in thinking. If you have not copy pasted an idea, then otherwise then you will not find that almost same patent has been filed. Like G. Marconi has copied the idea. For this is an idea of the radio in USA and European Union and or England was same, but that's
Hmm.
different issue.
Right.
So most unlikely we'll do that, because we will have your own original idea, and most
Hmm.
unlikely it will match. But it is just reverse. If you have an
Hmm.
Indian patent,
Hmm.
one can file also the US patent taking your idea.
Hmm. Hmm.
Be aware of it.
Exactly. Exactly. So we have to target the bigger market in which we need to protect our ideas.
So,
It is not a.
but US patent cost quite huge amount of money, and its licensing fee is also huge from the Indian point of view. So, if you are very much sure, that it is beneficial, then only you look for the foreign
Mm.
patents.
Correct, correct. But it should be taken into consideration if we are having this
You
patent.
can actually, once you get an Indian patent, so you can, there is a something like, you can write, there is a process that doesn't take much money. Our institute does that. It takes around $1,000. So
Mm.
that is also not small money, to at least
1
to
lakh,
me.
around 1 lakh.
Huh. So
I know.
that will actually circulate among this actually European Union, USA, and Japan. That this patent has filed in India, and likely this will be patented your countries.
Right. So that's
Just
a
to
caution
communicate
being
that
said.
information, you require to spend around $1,000.
Okay. Okay. That's a very good strategy. In fact, that can be taken just to keep abeyance, any sort of, same idea being patented in different countries at a lower cost. Yes,
And
sir.
next is basically another one to important point I want to tell you that you are granting patent from the date of filing. Okay, so
Oh,
that you have filed, it took maybe 1.5 year to get the patent, but from the day one you get the patent.
mm-hmm.
Got it? Let's say I have filed today
Okay.
and I get the patent after 1.5 year. I don't know because I am filing the first patent how to first it,
Mm.
but you will get the patent from today only, from 19th of June,
Okay. Okay. The data filing,
date
if
of
at all
filing the
it
patent.
is approved. Okay. Okay, sir. So whatever time the patenting, this thing does, so that is at my own cost. So this is added to my 20 years, right?
Definitely. But
Mm.
you get, but uh, yes, definitely. 1.5 year, if you are not granted patent, you cannot write that you got the patent. Only you
Mm.
can write
Mm.
that you have filed the patent.
Right. Right.
But you can start the business
Mm.
once you file the patent,
Mm-hmm.
and patent grant needed for the legal enforcement, because if someone says that you have infringed the idea of someone, but then you
Mm-hmm.
can say that, look, I have patented from this date.
Correct. Correct. I've already applied for that. It is under process or something like that. So I am not infringing on anybody's ideas or something.
Right?
Right. Right.
So in our discussion, if we put in the again little summarized view,
Hmm.
so there are 5 steps to file a patent:
Hmm.
conduct due diligence for the nobility by brainstorming and etc., and innovativeness and the applications.
Hmm.
Then with a proper searching etc.
Hmm. Hmm.
Then file the patent application online at, in India it is IPO. We call it is IPO, India Patent Office,
Hmm. Hmm.
and you will get an application number
Acha. Okay.
instantaneously.
Okay.
Like if you apply for the GST, that happens, right?
Mm-hmm.
Same thing.
Right.
Then application is published in the patent journal,
Mm.
and it generally takes 18 months, but you can expedite the publication by, there is another fast forward mode. You require to pay around 5-6,000 more.
Acha. Okay. Okay. Just like a Tirupati temple
All
visit,
right.
where there is ordinary line and there is a VIP
So
line in which you have to pay.
examination follows. So
Mm.
publication can be expedited.
Mm.
So we generally, the reviewers, you can ask to see the prototype or demonstration. This you can also do
Awesome.
once they give the, if they allow. It may so happen that like paper review they do that,
Mm.
but sometimes they come physically to verify that.
Acha. Okay. Right.
Okay, so if
Mm-hmm.
you are claiming the working prototype,
Acha.
so it is, sometimes they ask to attach the video videography.
Mm.
Okay, So that they may ask, and that is the examination.
Okay. Okay.
Then response to the controller's objections and proceed to the grant patent. Though then they will circulate in a journal that this patent required to be filed. If anyone has any objection, please uh, please write it. And if anyone has any objection generally, uh, then it has been communicated to you. You require to defend that, and sometimes
Mm,
it becomes a little messy among
mm,
the companies. Like there are many cases like ABB and G fought the patent cases uh, while filing stage also.
mm, mm.
So that's not a case anyway. For that, these are the company rivalry. But in our cases, if someone responds that no, this is our idea, then you require to defend it. So these are broadly the patent filing process.
Mm, mm. Right, sir. So quite interesting and very sort of steps are very, very well spelled. It is not like there is not much of an ambiguity between the different steps. So first we need to understand why we need to have a patenting done, what advantages is bring to us, what that we had discussed, and then the process approaching
Right.
the offices and the background search that we need to do, which is very important to establish the nobility of the idea, and so that in the later cases there are not much of a chance in which the idea is getting challenged or something like that. So the more background research we do, the more smooth flowing will be our patenting process at a later stage when we actually file that up.
Uh, in that background, I'd like to tell you something. There are some legal issues also.
Okay,
You
right.
cannot file a patent outside India.
Acha.
So
Okay.
there is a legal sections
Mm-hmm.
39 FFL.
Mm-hmm.
So section 39 of the Indian Patent Act requires Indian resident to first file in India before seeking the foreign patent protection.
Okay. Okay.
If you are
Okay.
a person of Indian nationals, if required to file their patent in India first.
Hmm. Acha. Okay.
For direct, but I don't think it is an issue for the startup. But still, I wanted to say for
Hmm.
direct foreign filing without filing India, uh, you know, we require to give filing a license fee, and we require to have a no objection certificate from our Indian Patent Office.
Okay. So either way, I mean, there is a possibility, and in a process, if you are taking India as a geography, you should be, first taking care of that geography in terms
Definitely,
of.
even if you are person of Indian nationals,
Hmm.
required to first file patent in India. That is the rule 39 says.
Correct. Correct.
Thereafter, you are allowed to file directly, and if you directly want to file the Indian US patent,
Hmm.
then definitely there is a different procedure, foreign filing license we say, that is called
Okay.
FFL.
Hmm. So suppose today I have filed for my patent today, let's say. So maybe tomorrow, as because I have already filed, it is under process. So can I go and file it for USA or any other foreign country?
Yes, then
Is
you
it allowed?
require to have a FFL. FFL essentially seek that whether this patent can be a threat to the Indian national security or not.
Okay. So once I am awarded the patent in India, once that process is completed, that 18 months and all those things that you're talking of, that is completed and the patent in India belongs to me, then I can go and automatically
But
file
let's
for
say you
other.
have filed a patent
Hmm.
of Indian national interest, then
Hmm.
you require to get a clearance.
Okay.
Huh?
True enough. True enough.
Let's say someone has patented from the bark on the A, so they are not allowed to actually file patent in USA.
Mm-hmm.
Maybe, I don't know.
Oh, so there are restrictions which we need to follow,
And
in terms
legitimate
of the law.
restrictions
Yeah,
is there, definitely.
uh,
Uh,
obviously. So
because you know
restrictions
that
that are there.
your patent should not be the security threat to the, if you have filed
Correct,
a patent to the external world, it should not be the security threat to the India.
correct, correct.
That is the whole idea.
Right, right, right.
So
I
for
mean,
this reason,
national
it is
interest is
called
paramount.
foreign filing license. We
Hmm.
require to get a clearance. MEA is involved, Home Ministry is involved, many ministries are involved.
Hmm. Hmm. Hmm.
Even Ministry of Defense is also involved.
Correct, obviously, obviously.
So FFL actually ensures that investor invention related to the national security or the sensitive technology are reviewed before the foreign disclosure. As simple as
Correct.
that.
As simple as that. So whatever
And
we are actually proposing, it doesn't have any. It's benign in our case, in which it doesn't have any sort of repercussions on our national security agenda or anything on
the
our
sensitive technologies, that's all.
right
Strategic
sensitive
technology.
technology which can be used in different other formats, which can be detrimental to our national security. As simple as that. So national interest paramount, then comes whatever we are discussing
Definitely.
with the. So that is very important to note.
Uh,
And anything and everything under the sun, any idea that you want is open to you to go for
because
a
many
patenting.
because like you startup in AV, now
Hmm.
our defense sector is also opening up.
Very much, very much. It is opening. It
So
is
since
the
our
next
defense sector is
agenda.
opening up, and
Yes.
any company files patent in defense sectors,
Hmm.
so that restriction will be applied to them.
Obviously, obviously, because a lot of technological innovation is happening.
Like
In
definitely,
fact,
you make a air defense system.
mm,
Of course, you ultimately Pakistan get catch hold of that patent. You don't want.
no, no, obviously not, obviously not. You see, if you see the, terms of the foreign maturity, technology which has already matured, which are being sold to different countries, over there also, that the other episode in which we are talking of the source code, it is protected. Nobody has access to that. So you cannot tweak with that part, so that which is actually the
Definitely.
brain of that technology. So it can be
By the
sold.
way, I just add one thing, that is
Hmm.
FFL, that is foreign filing license, is granted by the form. You just require to know a little bit. That's
Yeah.
all. Form 25
Hmm.
with a standard response time of 21 days. Generally,
Okay.
if you don't have that implication,
Hmm.
you can file it and you get a response in 21 days.
Okay.
Except the defense atomic energy, that's what I told you.
Okay. Okay. So let obviously, as per the sectors, it will have its own nuances. It will have its own repercussions. So
Right.
yeah.
But you can get FFL in 3 weeks. It's not a very big time.
Oh yeah. Okay. So
Except,
someone who is, suppose we have an idea or innovation being done, or suppose an invention is done. Suppose in food processing,
no,
which can be termed as a benign in terms of our
this
security and
question
all those.
comes, comes when maybe you have a US partner.
Mm.
Okay. So you have an Indian company here as well as the US, your US INC there.
Mm-hmm.
there.
Mm.
So you want to have a joint patent.
Okay.
Sometime, it is started by an NNI, let's say, or per person of Indian origin.
Mm-hmm.
So they want the patent India as well, because our manpower are cheap, so they develop the patent in India. They develop the idea and prototyped in India, and they want to have a patent also in USA. So
Right.
for them, that foreign licensing is very much required.
Mm-hmm. Okay. So, Dr. Bhattacharya, if is there any, if someone is totally benign or is not aware of this whole process, is there any step up mechanism or some literature available in any of the website in which they can refer to and understand the process?
Again, I'll share the link. There is my colleague uh, has done IPR, all NPTEL lectures on IPR.
Hmm. Right.
So that is 20 hours sessions, and he
Mm-hmm.
has explained step by step
Mm.
patent, copyrights, everything.
Okay. Right. So
So you
if
can
if
refer
that link
that.
can be shared, so
But this purpose of half an hour or 1 hour discussions is that it will give some idea.
right,
So you
definitely.
go to that lecture in detail and you
Hmm.
can find it out. Of course, I learned it from the website. You
Hmm.
visit to the IPO website, you get all the details.
Correct. So the basic ideation that we are doing is just to entice the viewers'
I just create the initial interest so
interest.
that it's not a very tough job.
Yeah, and nothing, there are certain inhibitions from new things when we
Right.
think of IPR, when we think of these big terms, so-called patents, etc. We think these are untouchables for us. We should not be venturing into it. We should take a bypass and do whatever we are doing.
And
But we should
another
have the
aspect I
consequences.
want to
Yes,
add here,
yes, sir.
you can give also power of attorney,
Okay, to a
right?
person who would be your entity, an entity can
Right.
give a power of attorney to
By
another
Form
entity.
26,
Hmm.
you can entice another person on your behalf,
Hmm.
my mother given me the power of attorney to take rent of her property, something like that.
Okay.
So same way you can give the power of attorney to the another person's
Hmm.
to file a patent on your behalf.
Okay. But whosoever is holding the power of attorney, I mean, is it defined that whether
Yes,
the
they have their own terms and condition.
okay, the rights are
So that
defined?
because let's say if he's an entity, then that entity has the power to actually to earn the revenue, because give it to anyone,
Hmm.
because we do that sometimes, because I am inventor, I don't know much business,
Hmm.
so that we outsource to any other third party, they do the business on our behalf.
Right. 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 So.
So that can also be considered,
Hmm. Hmm.
because you
Hmm.
consider on your own business, and then the patent, they will find it out the prospective customers for your patent and do the needful. So for this reason, we make
Yeah,
it
that also can be in a way we can also think like if you're having a mother company with a lot of subsidiaries, so the company
right. It may
holding
be
of
its
patents
own
can be.
subsidiary also to give it.
Yes.
So there are
Yes.
many ways to do that. So these are
Yes.
the uh,
So those comes
legal
under the
issues.
detail issues in terms like how to handle the patenting rights and how to, the proceeds that we get from selling patents or whatever the innovation part which brings to our company. So those things are related, and it's actually the process in which you are trying to manage your IPR.
Right.
As simple as.
Because you are not loading your system.
Correct, correct. So everything is having its own ecosystem. We are putting different things into its places and not mixing up. And when whichever is required, we are taking benefits from that, so that the systems are isolated, but the systems are talking to each other. That is how we are developing the ecosystem right now in every field. Uh, so I think that is great, sir. It has been a you know
Acha, I just
for
wanted
yeah,
to tell you something. I think it will be relevant before I finish it.
yes, sir.
Please note that there is no international patent
Oh, so
or
that means
universal
I
patent,
cannot have a global patent. It has to
right?
be
So valid
territory
across the
specific.
all country, and the patent must be filed separately in each jurisdiction.
But why can't we have it? Because we have United Nations,
That
we
is
have
the something that WTO is working on it.
yes, we have such
Okay.
a umbrella.
Uh,
But
so
obviously, globalization is under threat, sir. That is
uh,
also a
but
geopolitical
that is
scenario.
also, there'll be difficulty also. Na? Let's say one drug. If some drug company filed a patent in USA, and
Mm.
ultimately here you are denying in your
No, that will be
company
very
to
costly
manufacture
for
the
us.
same drug, so there is a cost priority also involved, no? So in
Definitely.
drugs, in cases that is quite important, where you can actually allow other company to manufacture that drug, have all
Mm-hmm.
those issues.
That is how we are actually doing our drug manufacturing to some extent, because for a molecule, the cost of development of a molecule in Europe or North America is
Right.
very, very high, and they are actually the biggest development partners. We are majorly into generic drug production, being the pharmacy of the world. So obviously, we take those molecules. We have a generic molecule, done. But if there is comes under the patent as a global scenario, it will be difficult for us. So that one sector is there, but obviously everything has its pros and cons.
Acha, in that regard, I wanted to say whatever you said. There is one. There is a two organization that is working for it. One is WIPO,
Hmm.
and uh, that is an organization definitely. That is a World Intellectual Property Organizations. They actually promote education supports for filing IPO in different countries.
Hmm. Hmm, hmm.
And another is that it is among the mostly nations patent cooperation treaty.
Okay.
So it also simplifies international filing
Hmm. Hmm.
and giving the inventor or new investors time to 30 months to enter the each individual countries if you already have a patent in another country.
Okay. So
So
that's
this,
a bilateral sort of an agreement that
ah,
we must be
right,
having.
this
Okay.
you can also explore.
Right. This is
Okay,
full of
I
information, sir.
think today I want to conclude the discussions today. So I hope
Yes.
that this discussion is helpful for our those who are startup or students or the institute.
Hmm.
Ah, they are trying to make try to file a patents and all those things. So we should encourage our student to file a patent,
Correct.
right?
Correct.
So
Correct.
dissertation topic,
Hmm.
there is a you you do your dissertation topic in a motivation that you can file a patent.
Right. Right. And also applies to individuals who are thinking of various ideation can go for filing of their patent, their ideas, and getting the IPRs in their name, which can be then helpful for their, developing it into a commercial level. Means I am developing into a new sort of a level in which the product comes out, which can be beneficial to the humankind in all aspects. Maybe it's EV or something like that. We are discussing, we are bringing in EVs and defense sector because in India these are the things which are very, the technology is fast moving and a lot of innovations and inventions are happening in this sector. So focus is on that. But frankly speaking, sir, there are other sectors also in which a lot of innovations are happening. Small, tweaks which help in multiplying the efficiency level is also taking place. Maybe those sectors also look into this sort of a concept in which they need to protect their IPRs or something like that. So today I think we had a very good session, sir. As we were discussing, more to come. As already highlighted, we are looking forward for your time on more on BMS. Also, one thing that I am really looking forward from you is in terms of the substitute of lithium ion, which we are talking of sodium ion, the sort of innovation level India has achieved, and how we can be self-reliant on that. And lastly, sir, just a thought in the EV cycle itself when we're talking of the product, how to recycle the lithium ion batteries, what are the best possible ways? If we can take those topics in different scenarios. And also, you had promised about some prototype, distinctions, live case study that we can do to bring in more
Right.
perspective to the
We have.
EV
I
cycle.
have promised a lot, so I have to keep up my promises.
No, we will
Anyway,
go. We will go as
so
per your time availability, sir.
uh,
No
as
hurry.
per my availability,
Yes.
I'll do that. I
Mhm.
also request listeners to actually like our videos, so that enthusiasm keeps
Right.
coming, so that
Right.
we can share
Right,
our
sir.
experience and idea to you, and I hope you will be benefited. Thank you.
Thank you, sir. Thank you so much.
Thank you.
We wish that we meet again soon, very soon, in the next episode. Thank you, sir.